meine Arbeit für richtig hält. Ob du glaubst, dass ich fleißig gewesen bin, dass ich gearbeitet habe, dass ich mich in diesen Jahren für dich eingesetzt habe, dass ich anständig meine Zeit verwendet habe im Dienste meines Volkes.
Protesters say they feel angry over Trump's attempts to expand his presidential power, including the treatment of immigrants and cuts to federal.
Welcome to a special edition of Legal AF. Donald Trump, as we know, has been using false claims of emergencies in America, emergency powers that he needs to have, national security crises, because that's a way for him to try to blow through the separation of powers and aggrandize even more power, as we're watching really the only presidency in modern history that, at least publicly, with Nixon, it was behind the scenes, but publicly, we're just lurching from one abuse of power to the next. And what we want to do here on Legal AF is bring in experts to brief our audience about these issues. I mean, as I like to joke, with my 35 years of trial experience, I can bring people to the courthouse and even to the front door of the courtroom. But for the people that are in the courtroom or advising the people in the courtroom who are on the front lines, the first responders for our democracy in the courtrooms, we got to bring in the experts. And I'm so pleased today to have Hina Shamsi, who is the director of the National Security Project at the American Civil Liberties Union, the ACLU. And everybody knows who follows Legal AF how it warms the cockles of my heart to talk about the ACLU and the work that they're doing in the trenches. I mean, we talk about the attorneys general and the 50 cases they filed. We've talked about the public interest groups like Democracy Forward and the ones that they filed. But the American Civil Liberties Union, both in the first term and in the second term of Trump, are really leading the charge. And so I want to bring in Hina Shamsi. Hina, welcome to Legal AF.
It's my pleasure to be with you. Thank you for having me.
Yeah, we were joking before we started recording that, to give our audience more confidence and make them sleep better at night after the election and before the inauguration, I was downloading the ACLU briefing book about every major issue from reproductive rights, women's rights, immigration rights. And boy, did you guys get it right in your brief about what was going to happen with this administration, to give my audience confidence about how groups like the ACLU on the front lines were prepared for the Trump administration. And now some people might have thought, wait, the ACLU has a national security unit within it to talk about everything from constitutional compliance of presidential policy to human rights to civil rights. Why? Well, now we see why. We see a president who's using the mantle, the fake mantle of national security threats to try to cram down I'll call it his unconstitutional abuse of power. So why don't you bring our audience up to speed? What keeps you up at night, and what is your project and the ACLU doing about it?
Well, I have to say that there is a long list of things that keeps me up at night. One of them that we started working on, and I really appreciate you shouting out our briefing papers before, because we did spend a lot of time just thinking through what has he urged before, what are the kinds of national security issues that have come up since my project was founded in about 2004, because presidential abuse of power isn't new in our democracy, but we were worried, particularly after his first administration and the things that we saw there, that it would become that much more extreme. And one of the things that we were most concerned about is the abusive use of the military on domestic soil, and the ways in which federal civilian law enforcement and intelligence agencies could be further turned inward against our own population. And those are the things that I think are really coming into play. These are the things that we started preparing for, I want to say about a year ago, particularly with respect to the deployment of the military. And we saw that come into play with California and now with DC. And I think that the use or invocation of national security or emergency powers is being used by this president as essentially a blank check to bypass laws and checks and balances in ways that are harmful to our people, as well as the communities and institutions that are involved.
Judicial deference and the American fascist state. That's the subject for today, and it may seem an obscure topic, deference, but it is very much at the heart of the police state that's being established by the use of military under various laws. Military used against our civilian population in Washington, D.C., and in Los Angeles. Now, historically, courts have been very deferential, for better or worse, to presidential declarations of emergency. This I report to you from Jill Hasday, a University of Minnesota law professor, who's borrowed, I think, the phrase from Steve Vladeck of Georgetown Law, one of our most foremost constitutional scholars. However, some courts have been willing to engage in a deeper review of whether an emergency actually exists and if the executive action is justified, rather than solely deferring to the president's declaration. Some notable exceptions to judicial deference are from the past: Youngstown Sheet and Tube versus Sawyer, 1952, where the Supreme Court ruled against President Truman and his seizure of steel mills during the Korean War, stating he lacked the authority to seize private property without congressional approval. Next, Ex parte Merriman in 1861, where Chief Justice Roger Taney ruled that President Lincoln's suppression of habeas corpus during the Civil War was unconstitutional, asserting that only Congress could suspend that writ. And finally, Ex parte Milligan in 1866, where, writing for the court, Justice David Davis held that trials of civilians by presidentially created military commissions are unconstitutional. Specifically, it is unconstitutional to try civilians by military tribunals unless there is no civilian court available. The military commission therefore did not have the jurisdiction to try and sentence Milligan, and he was entitled to discharge. That was a very important case that pitted military law against, and martial law against, Article III courts and their right to function. 3. So what are you on about, Ryan? What are you talking about deference for? What is this all about? And here we go. Recent cases that have arisen wherein deference is not only relevant, but it's key to the decisions taken by the district courts. And we have the recent Newsom versus Trump in the Ninth Circuit Court of Appeals, where a 3-judge panel made a decision in part because it extended deference to the executive on the question of what constitutes an emergency, that justified the invocation of a statute that permitted the federalization of the National Guard, as well as the introduction of the military onto the streets of California, where the Court of Appeal 3-judge panel agreed with Trump while extending deference to his subjective judgment that there was an emergency and they stayed the lower court injunction against him while the matter is being litigated today. End result: the continuation of a clear violation of the Posse Comitatus Act, prohibiting the use of military against civilians in so-called law enforcement matters during a protracted litigation, goes forward. In law, deference means that a court shows respect for and yields to the judgment of another legal actor, such as an agency or a lower court, in this case, the executive, rather than substituting its own judgment. It is a principle of judicial review where courts refrain from second-guessing or substituting their own views, particularly when reviewing decisions of other bodies. Deference is perhaps the most important concept and practice in law. It lies at the core of every system of precedent, appellate review, federalism, separation of powers, all of which center on how one actor, in this case the president, this demented beast, can deal with previous decisions. Oddly enough, deference is also one of the most underanalyzed and under-theorized legal concepts and practices, perhaps because its applications are so varied. This, according to Gary Lawson, Boston University School of Law, and Guy Seidman from the Rasner School of Law in Israel. Now, there are different kinds of judicial deference, and I want to explicate all of them so that you, the viewer and listener, have an idea of how they're being used, how deference can be used as a vehicle in a structure determined to become tyrannical, the establishment of a police state based on one man's conclusory allegation that there is a national emergency, if this is not questioned by the courts. Now, so this is a common deference is common in administrative law. It means that the courts may defer to an agency's interpretation of a statute or regulation, especially when the law is ambiguous. That's in general. There used to be something called the Chevron defense, which is a specific type of judicial deference established in the case Chevron for USA versus National Resources Defense Council, where courts defer to an agency's interpretation of an ambiguous statute that the agency is tasked with administering. However, a recent U.S. Supreme Court decision has overturned Chevron, requiring courts to interpret statutes independently. And this is Loper Bright Enterprises versus Raimondo, which overturned Chevron. Another kind of deference is deference to the lower courts. When an appellate court, including the Supreme Court, reviews a lower court's decision, it may defer to the trial judge's findings of fact or legal conclusions, particularly on matters of discretion, unless there is clear erroneous error. Well, that's double erroneousness, which is nonsense. Clear error. Lastly, there's a defense to expertise, and courts may also defer to the expertise of other bodies, such as administrative agencies, when they are making decisions within their own area of expertise. So, let's get back now to Newsom versus Trump. Washington, D.C. is another issue, but let's focus on this. Getting back to Newsom versus Trump, 1. The first issue: which law has Trump utilized in order to explain and justify his intervention by National Guard troops and subsequently Marine Force troops into the streets of LA and into the state of California. He used not the Insurrection Act, he used 10 U.S.C. Section 12406. And I'm going to read that to you so you understand exactly how and why he's used that act. That act declares, 1, the United States, if it's invaded or in danger of invasion by a foreign nation, he can invoke the act. 2, if there's a rebellion or danger of a rebellion against the authority of the government of the United States, he can invoke the act. And 3, the only plausible explication of the act is that the president is unable with the regular forces to execute the laws of the United States. So, the president may call into federal service members and units of the National Guard or any state in such numbers as he considers necessary to repel the invasion, which doesn't exist, suppress the rebellion, which certainly doesn't exist, or execute those laws, which is his argument. Orders for these purposes shall, not will or may, shall be issued through the governors of the states, or in the case of the District of Columbia, another case we can consider, through the commanding general of the National Guard of the District of Columbia. And there we're dealing with another act, it's called the Home Rule Act. He could have used the Insurrection Act of 1807, which is Code 10 U.S.C. Code Section 252, the use of military and armed forces to enforce federal authority. And that comes into play whenever the president considers that unlawful obstructions, combinations, or assemblances of rebellion against the authority of the United States make it impossible to enforce the laws of the United States in any state by the ordinary course of judicial proceedings. He may call into service such of the military of any state and use such armed forces as he considers necessary to enforce those laws or to suppress the rebellion. But there's no rebellion here, and we cannot have deference to the mad, conclusory allegations of an out-of-control rogue presidency. And it goes on, there's Section 253, which is more likely for him to use as an excuse for invocation of the act, interference with state and federal law. The president, by using the military or the armed forces or both, by any other means, shall take such measures as he considers necessary to suppress in any state any insurrection, domestic violence, unlawful combination, or conspiracy, if it, 1, so hinders the executions of the law of that state, the laws of that state, and of the United States within a state, that any part or class of its people is deprived of a right, a privilege, an immunity, or a protection named in the Constitution and secured by law. And the constituted authorities of that state are unable, fail, or refuse to protect that right, privilege, immunity, or to give that protection. Or 2, opposes or obstructs the execution of the laws of the United States or impedes the course of justice under those laws. So, getting back to Newsom versus Trump in the Ninth Circuit Court of Appeals, let's talk about how they decided to grant the defendants a stay based on deference to the president. The district court had concluded that the plaintiffs, that is the state of California, Newsom, were likely to succeed on their claim that the president's order was ultra-virus because none of the predicates to federalization required under 10 U.S.C. 12406 actually existed, and the order was not issued through the governor as the statute requires. The defendants, as you know, immediately appealed and filed this emergency motion to stay the temporary restraining order. The panel in the Court of Appeals, per curiam, the panel held that it had jurisdiction under the All Writs Act to grant a stay of the TRO pending appeal. Moreover, because the TRO possessed the qualities of a preliminary injunction, it was reviewable under 28 U.S.C. Section 1292A1. In granting a stay pending appeal, the panel held that defendants made the required strong showing, laughable, that they were likely to succeed on the merits of their appeal. Doubtful. But forget that. Although the panel disagreed with defendants' primary argument that the president's decision to federalize members of the California National Guard under 12406 was completely insulated from judicial review under the political question doctrine. This is complete nonsense, of course. The panel was nonetheless persuaded that long-standing precedent interpreting the statutory predecessor to Section 12406, a court's review of that decision must be highly deferential. Now you see why it's so important to not only analyze deference and judicial thought, not only just to examine it, but to scrape it and scrap it off the wall and remove it from the legal lexicon. It shouldn't even exist. Presumption, maybe. Deference, never. And this is the danger. Consider we have a madman, fascist, monster, narcissist, lunatic, sexual predator, and rapist in the White House who declares a national emergency where there isn't one, without facts to back it up, without analysis. If this is the way we're heading, taken together with the unitary theory of executive power, we are in the midst of transforming our country into a goddamn fascist police state. Military on the streets, Democratic senators and congresspeople being persecuted and prosecuted, the judiciary having its orders completely ignored, and a complacent, out-of-control, rogue, Nazi majority Supreme Court. Wake up, America, and support me. How about we get by this algorithm? Thank you.